Hi, it's Connecticut personal injury attorney Ryan McKean here. Today I'm going to talk to you about injuries that occur in Amazon warehouses. Now, our firm, Connecticut Trial Firm, has one of the largest, if not the largest, verdict nationally arising from a warehouse injury. We had a $100 million verdict for an injury that occurred at Rexel in Hartford. So we spent a lot of time learning about warehouses and injuries that occur in them. And certainly warehouses are very dangerous places. You have equipment, product, shelving, lots of people, very fast moving, and it's ripe for injury. And one of the first things to know is that certainly if you get hurt in a warehouse, you have a workers' compensation claim. And I'm not going to be talking about that. Suffice, you should contact a workers' comp attorney to understand those rights. And that's a claim against your employer, because in Connecticut, like most states, you cannot sue your employer. Your remedy is limited to workers' comp. The good news is that you get paid no matter what. They pay your medical bills and they pay your salary. The bad news is they don't pay all your salary. The bad news is that they don't pay for everything that you need for medical care, and your care may be supervised. They don't pay for things like pain and suffering. And there may or may not be, so what I'm going to talk to you about today is what I'm going to refer to as a third party claim. And what that means is pretty simple. Party one is you, party two is your employer, and party three is somebody else, okay? So this would be you against the third party, not your employer. So in our case, for example, our client was injured when a distributor shipped a product negligently. They had to affix product to a pallet. They did not affix product to a pallet, causing it to fall and crash on our client who was working in the warehouse. Also involved in that claim was a temporary worker who was hired, who worked for another agency who was using a reach truck. So we had a claim against the temp company because under Connecticut law, in most circumstances, not all, very fact specific, you can sue a temporary worker for injuries. You can't sue a coworker, but you can sue a temp worker. And you had a claim against the distributor who sent a defective package into a warehouse. So we were able to bring those two claims. So I'm really going to talk to you about third party claims. So in third party, it would just be that it would be straight negligence. It would be that that somebody packed something, most commonly in a negligent way, or a contractor was operating a reach truck or a forklift or something in a way that they should not have been, or that there was some defect in the property, because oftentimes you may work for one company and the different company actually owns the warehouse. So there could be a claim for like negligent premises. If there's a fall or defect in the racking system, it could be a claim against the manufacturer of the racking system. There's a whole host of parties that could have third party claims against. And so you can bring a lawsuit or make a claim against these third parties for injuries. Sort of the things that you need to know about it is that workers' compensation under Connecticut law and law, pretty much every state that I know of, can also they would have a lien on any sort of recovery. So things that they paid for your medical expenses, things that they paid for your lost wages, you may have to pay back. And oftentimes those liens are negotiated. It's not something to be too concerned about, but it's just something to know, as you're bringing a claim, if you're injured in a warehouse, that workers' compensation may have a lien. You're going to want to talk about that with your attorney. We've been successful in negotiating down liens. And honestly, fortunately, workers' compensation pays so little to medical providers that the medical liens can be pretty low themselves. So don't worry too much about it. Um, and just know that a third party claim is brought like any other lawsuit. Workers' comp would be a party to it, but they're only a party to try to get their own money back. Um, Weirdly, under Connecticut law, workers' comp can bring a third party claim on your behalf if you choose not to bring one. and they sometimes do that. But otherwise, your lawyer's going to really investigate the claim, investigate what went wrong, see if it was see what the third party did, if it was again commonly like a temporary worker, see what the relationship it was between the temporary worker and your employer. Again, there's often contracts that say who's responsible for what or who's liable for what, and that could be a fact-specific determination that your lawyer really has to get into to see if a temp worker could be sued, um, as we were able to successfully do in our case. So, if you've been injured in a warehouse or someone you love has been injured or killed in a warehouse accident, I can't say this enough. It's very important that you get an experienced warehouse injury lawyer involved in your case early. We want to see preservations of evidence. We may want to, get the OSHA report as quickly as possible. Engage experts in what has happened to see if there is a claim and see what the viability of it is, and also to make sure that your comp claim proceeds smoothly, because oftentimes they don't. We've had cases where checks should be sent and they aren't sent, and spent a lot of time making sure that the check gets sent on time by seeking sanctions in the workers' compensation process. So if you or a loved one have been injured in a warehouse accident, give us a call. We're happy to help. 860-471-8333.